Let's talk about the Fair Debt Collection Practices Act. Back in 1980, when I started practicing law, it existed, but it didn't apply to attorneys. Starting about 1986, if I'm remembering right, they amended it so that it does cover attorneys as well, as long as they're a third-party debt collector. And that's defined in the statute. The third-party debt collector has to do a certain number of collections every year to qualify as one. They obviously aren't the original creditor, that's another qualification. And if you qualify as a third-party debt collector, then you have to comply with a number of other rules. You can't engage in any unfair or deceptive acts or practices. I mean, that's common sense to 99% of us. And I don't, it always bothers me that it doesn't take very many to make everything hard for everybody. So you can't do that. You have to give certain notice requirements. If they ask you to validate the debt, you have to validate that, which is not necessarily what the internet tells them that you have to provide to them. We will get letters all the time saying, you are required to give us the date of the debt, and when it was incurred, and who it was, and the address of the person that you've got it from, and the amount. And that's not what's required. What you need to do is you do need to go get a note from the original creditor confirming that the balance is due and owing, that it hasn't been paid, and that they've reviewed their records and that it exists, and who they are, obviously. And we do a form that's actually signed by the original creditor. So we send that off to them saying, here's your validation, we're going to proceed. Now, if you get that request for validation, you can't proceed with your case until you validate it. Now, I'll be honest, there are times that we have cases where the original creditor will never get back with us. And when that happens, we drop the lawsuit. We write them a letter saying we haven't been able to validate. We're closing this account unless the creditor gets back to us, and then we'll get back with you. Because it's just not worth the aggravation. The other major motivation for complying with the Fair Debt Collection Practices Act is that it provides for multiple consequences if you don't. Okay, those consequences are $1,000 for every deceptive act or practice. And definitions vary. I've defended a number of those types of cases just because everybody and their dog, that's a nice cottage industry if you ever wanted to start a business. Just pursuing those claims, you can make a pretty good living at that, whether there's merit to them or not. Also, and the real kicker, which is why it's a good cottage industry, is you also get to recover your attorney's fees. And in the Fair Debt Collection Practices Act, there's no provision for reciprocal attorney's fees. So if you're the defendant in an FDCPA litigation and you win, you don't get compensated for proving that you didn't do anything wrong, which can be pretty expensive and is not a deterrent for people bringing suits just for the heck of bringing suits. What else do we have to do? So, and again, your collection practices, you can't be abusive, you can't harass people, you can't threaten people. Everything that would seem totally obvious to anybody that has a brain, but it is prohibited specifically by statute. But people's interpretation of what that means varies radically. And so if I call you, or I call you on the phone and say, we've got this debt from our client here, and we really wish you'd pay it, and we'd be glad to work payment terms with you. And you say, well, let me talk to my husband and we'll look at it and get back to you, or my significant other. And then we don't hear back from you, so I call back in a week and say, we never heard back from you. And then you say, well, haven't got around to it, let me know. If we never hear back, make a third call, they can say, oh, you're harassing me. And I've had lawsuits, not quite to that extent, but to one that's very similar, that, obviously it's not ultimately, but you still have to put on a defense. I just had a case dismissed, and I hate to admit I get sued, but it's just a fact of life if you do debt collection for a living. But I had a case that we just got dismissed about a week and a half ago. And the facts of the case, not getting too specific, is we had an account, we had a judgment against a defendant. She had made a payment arrangement to pay the judgment. and was complying with the payment arrangement, basically. We got additional accounts from other creditors, and so we're ready to go again. She had missed payments. One of my legal assistants called her and said, you know, we've missed on these payments, and by the way, we now have new accounts in our office that we need to talk about getting resolved. And she said, well, let me wait until after I get these paid off, which would have been November, and then I'll address those at the same time. Well, she pays them off. He says, okay, but we need to do it by November for sure. And I have a recording of this call. She calls back, she pays it off. She doesn't happen. We sue her in December. Her response is, and this is her letter from her attorney, A, you didn't comply with our payment arrangement, which was a separate case altogether than what she's bringing this on. And B, you told me you wouldn't file suit until after the holidays. I sent her attorney a letter with a disc with the phone call on it where he says specifically, it needs to be dealt with by November, and he still files the lawsuit. So my attorney was very happy. I was not. But it was dismissed and now it's done, so that's good. Okay. Also now, debt collectors are becoming more and more subject to the Consumer Finance Protection Bureau, right, CFPB. Bankers, every banker I've ever talked to in the last 4 years or 5 years, actually probably more than that now, huh? Probably 8 years. As soon as you mention those 4 letters, you watch their face start turning red and they start shaking. Because it just creates a whole new layer of things that they need to comply with that I don't see how they really benefit the debtor themselves. They benefit the CFPB because anything that they are able to retain or recover in terms of their damages or whatever, beyond what they do for reimbursement of the creditor or the debtor, they get to keep. And so their budget is based on what they recover. And so I may be a little politicized because I do have a dog in the fight, and I'll admit that up front. So there's another side to this story, I'm sure, and I've actually gone to classes and seminars where the CFPB was represented by one of their major executives and whatever, and they tell a good story too. But bureaucracy for the sake of bureaucracy has always bothered me, and that's kind of what this seems like to me. But we have to comply with that. I now have a policies and procedures guideline that's basically like this because we have to have a procedure written down for everything that we do. Well, just the little bit that we do that we've talked about this afternoon, you can see we're writing down, well, okay, here's how you do this. You look at this, you do this, you go into the computer, you push the, and again, this part of it's way beyond me. I have smart people to do that. You'll go in there and you go into this program, and this is how you figure out how to do that. This is how you pull your complaint. This is where you get the input for the materials on the complaint. And then this is what you need to do to make sure that it goes to the constable in the right way with the right letter. And all of that has to be written down now. Well, when I started practicing, I would sit down with my daughter that was my secretary at the time. Well, no, when I started, it wasn't my daughter's, it was 8. But when I started, basically when I started doing this in my secretary, I would just say, okay, let's do this. She'd pull it out, we'd crank it out, and it would be done. We didn't have any policy other than we both knew what was supposed to happen next. So it's, you know, practicing law as a whole, as you all know as being paralegals, and practicing law in the collection field, I don't want to say particularly, but it's certainly relevant, has become incredibly more complex and incredibly more, lack of a better word, dangerous. Because it's just not, the presumption has changed. When I started practicing, there was still a circuit court system in Utah. Probably, I don't know if any of you remember that or not. It was a long time ago. And circuit courts handled anything under $10,000. I think 10. That was way more money then than it is And then anything over 10 was district court. You could file the smaller cases in district, but you didn't, just because there was no point in doing that. So we'd go to circuit court on a regular basis. When they combined the two, because I think the circuit court judges didn't like being called circuit court instead of district court judges, was one reason, and the pay was better as a district court judge. But in circuit courts, when I started there, I had a judge once tell a defendant, well, it's your obligation to understand how these rules work. If you choose to defend yourself, you need to understand how these work. Now, I get that's a hard thing to say to somebody, and I've gotten softer over the years in terms of my attitude. Then I was, yes. But now I'm not so sure, you know, I'm a little softer in regard to that. I get that it's a system that they're not familiar with. It's pretty intimidating. Going to court, it's amazing. You go to a pretrial and they say, oh, you're really pretty nice. And yeah. So, where was I going with that? I'm sorry. Oh, so the circuit court system was merged with district courts, and now the district courts, I think, are less happy about having to handle debt collection cases. So they keep trying to farm it out. I went to a seminar about 2 years ago down in St. George for one of the sections. It was the spring bar. And I went down there, and one of the sections was, let's make all collections go to small claims. You know, for under 20 grand or whatever the limit of small claims is now. I think it's up to that by
It's
now.
11,000 right now.
Wait, it's what?
11,000.
11, okay. And my first thing was, well, by statute, we're precluded from filing in small claims if we're an assignor of a debt, assignee, sorry, of a debt. So that wouldn't work. I mean, and secondly, you're going to have to create a really big small claim system. My office generally files, just volume-wise, so you know, actually files probably between 600 and 900 cases a month. Okay? Small claims is not equipped to deal with that. District courts claim they're not equipped to deal with that, but they're lying. Because 90% of those are going to be defaults. But regardless, you know, trying to say, let's go back to a system that was working well and we disbanded is kind of just where it is now. So the district courts are not excited because I don't think they enjoy doing collections. I think it's not very pretty. It's not, generally speaking, it's not probably incredibly intellectually stimulating. It can be on occasion. I've had some interesting experiences, but that's stories for another day. Again, my book will be out eventually, or not. But collections, basically anything you guys have questions about, that's kind of all I have, so. Anything? Okay, well, thank you very much for letting me come present today. I appreciate that.
Thank you.
And if you have any questions, you can call me. I don't know if yeah.
Do you mind talking more about the family expense statute?
Oh, thank you. That's great. In fact, we ought to talk about that specifically, and I actually brought a copy of that. I also was going to talk about collection agency fees. So let's talk about those. That's great. Thank you. They even printed them both off, so let's find them. Okay, so the law has changed some, and this will give me some time too, because there's a lot here. Back originally, if there's a written contract, contracts can provide for a lot of different elements of recovery that aren't traditional in just common law. Okay, a contract can provide for an interest rate that's beyond 10%, which is the statutory rate if there's not a rate set. A contract can provide for reimbursement for attorney's fees. Our contracts, we really, really work with clients to put in a provision that says if it has to go to a collection agency, you'll pay the fee the collection agency charges the original creditor. Because then the original creditor actually has a shot at getting close to 100% of what they're owed. Prior to that, every collection agency I've ever had any affiliation with, with my own associated with private clients, I've always taken between 25 and 33% of everything I collect. So they're getting between 75, 66 and 75% of what they're owed at the back end, which, as I pointed out, very obviously, I thought that that was better than the nothing they had before. But still, that's a relevant factor. So collection agency fees were set forth in contracts, and so they were enforceable. Now, what had happened is and there's a statute that provides for collection fees. It's 12-1-11. We read the definition out of that beforehand. And a collection agency can act, or a creditor can actually, original creditor can actually collect their collection agency fee back within certain criteria. So we'll talk about what those are a little bit there. And this is basically a creditor may require a debtor to pay a collection fee in addition to any other amount owed to the creditor for a debt, if it's not prohibited by law, federal or state, which generally they're not. I don't know of any that are, in fact. The creditor contracts with a third-party debt collection agency or licensed attorney to collect the debt. So if I were running my percentage still with some of my clients, if they agree to pay me 25% of what we recover, that's a collection fee that can be recovered, even though I'm a licensed attorney, not an agency, because I'm a third-party collector. And the third-party debt collection agency that is registered under the collection agency statute. There's a written agreement between the creditor and the debtor that creates the debt and provides for the imposition of the collection fee in accordance with this section, and the obligation to pay the collection fee is imposed at the time of assignment. Hang on to that because we'll come back to that, it's important. To a third-party debt collection agency or licensed attorney in accordance with the agreement. And the reason that's important is because they don't get the collection agency fee just because they're thinking about referring it to collections. They actually can only add it at the time that they assign it. So the original creditor can put it in as a line item as they're assigning it to the third party. Otherwise, they can't get it. And then it limits the collection fee to either what the percentage the collection agency is actually charging or a maximum of 40%. So if the contract calls for 50%, you can't get that. If your collection agency agreement is 25%, you can't get the 40% that's called for in their contract because you're only charging the client 25. So you can only charge the debtor 25. There's no windfalls in the statute. And that's done by a support, and when you ask for that, when you submit, if you're submitting a default judgment or even a judgment at trial in some judges, when you're submitting a default judgment, you have to have an affidavit from your client setting forth what the percentage that the agreement is between the third-party debt collector and the original creditor when you ask for your judgment. It's a line item in the judgment so that they can have that supporting for the line item. And then it says, and then this is clarification because we have some fights with the courts over the years about this issue as well, that an obligation to pay collection fee is in addition to any obligation to pay attorney's fees that might otherwise exist. When we first started getting interested in doing that, there were a number of courts that were ruling that you could either have a collection agency fee or an attorney's fees, but you couldn't have both. I'm not quite sure where they came up with that because the contracts were fairly clear, but they just said, nope, we feel like that's double dipping. And so that language was included when we did this for that very reason, to clarify that it's not an either or, it's both. Okay, the other one, statute that's actually changed in the last little while is the family expense statute. Now, there's been a family expense statute around since, forever. There are cases relating to the family expense from 1918. And we still cite some of them in some of our memos. But a family expense, just so we talked about this a little bit, expenses of the family, which can be clothing, utilities. My definition is not as broad as some, maybe it's broader than others. And the education of the children, and this is where it gets interesting, are charged upon the property of both spouses or either of them separately, for which expenses they may be sued jointly or separately. So, if you've got two spouses, you've got a family expense, and we'll talk about what those are a little bit in a sec. You can sue one or the other of them, and they're both liable for all of it. Usually, I mean, we would do it both because there's more pockets to try to find money in. But if it's a family expense, both spouses are liable, regardless. Then if there's a written agreement, and this has changed, again, this is in response to judicial decision, is the next section of this provides that if there's a written agreement signed by either of the parties, that both of the parties are subject to the terms of the agreement. So Deanne Parry walks into Instacare with one of our kids, well, we don't do that anymore, but for 40 years we did, and signs a contract that says, I agree to pay a collection agency fee and attorney's fees and 18% interest. I'm bound by that as well under the family expense statute. That was amended in 2015 to make that a provision. Prior to that time, the signing spouse was obligated to everything under the contract, the non-signing spouse was not. They were still liable for the principal and the interest at 10%. If it was a higher rate, they'd only be liable for 10% court costs, but not for the other contractual provisions. And then it defines, for purposes of this section, family expenses are considered expenses incurred that benefit and promote the family unit. Items purchased pursuant to a written contract or agreement during the marriage that do not relate to family expenses are not covered by this section. Now, the reason that's in there is because there were some people that were really up in arms about this statute being presented and proposed. And that helped them, it was obvious from the first paragraph what a family expense is. They were way more comfortable with saying, here's also, yeah, that's really what it is. And then it also put one limitation on it, and I thought it was an interesting limitation, but provision 2 and 3, which are the two we just talked about, the written agreement and so on, do not create a right for attorney's fees or collection fees to the non-signing spouse for purchases of, and then it says food or clothing or home improvements or repairs over $5,000. So if you've got a contract for repairing the kitchen and you want to treat it as a family, or somebody's treating it as a family expense, and you didn't sign the contract, you still may be liable for the principal and the 10% interest in the court costs, but not the collection agency fee and the attorney's fees in the contract. What I miss on family expense statute?
Well, I was just wondering about medical expenses of the spouses themselves.
Okay,
And
it
let's say-
says expenses for the family.
So that would be considered part of the.
Absolutely.
Okay.
And that's been universal from at least 38 years that I've been doing it that long. And I've never had a judge say a medical expense is not a family expense, unless it's for, elective cosmetic surgery. I have had judges on both sides of whether mental services, rehab, that type of thing qualifies as a family expense. And I've had rulings on both sides of that question. Yes?
What about if it's a divorced family?
It's no longer a family
Okay.
for purposes of the statute. Now, if the family existed at the time the debt was incurred and subsequently dissolved, they're still liable under the statute for stuff that was pre-dissolution. So but yeah, if they're not married anymore, they're not husband and wife, or spouse and spouse, I guess, depending under the way the law's looked at now. And so therefore, there would not be a family expense. Now, there's also provisions in the Utah Code, and I forgot to print those off, and I apologize, but there's also a provision, I think, in the husband and wife portion. Nope, it's in parental rights, that says basically if you're providing health care for your children, both parents are liable for those bills, even if they're not married. So father and mother both are liable for medical bills for their children. There's been some messing around with that statute in the last couple of years up in the legislature, but the basic rule still applies. Now some of the changes on that used to be just straightforward. It was both of them were liable for their kids' obligations. The statute's been amended now that if you provide the creditor with a copy of the divorce decree, before it's gone past a certain stage. And like I say, it was modified twice in the last 2 years. So I'm not right on top of it because I don't have to worry about it that often. But if you provide a copy of the divorce decree, and our criteria has always been just whenever you get it, you're bound by the terms of the divorce decree in terms of partitioning out that debt. So if the divorce decree says you're 50-50, and one spouse comes in and pays 50%, they're done, even though under the statute, if they didn't provide the decree, they'd be liable for 100%. So that's out there as well. And also, just in relation to medical, there is a statute, and I think it's, that provides that really insurance isn't a defense to a medical bill. You know, quite often we'll get defenses on medical bills that say, well, my insurance should have paid this. And our response is always, well, that's a contract between you and your insurance carrier, and there is codification of that rule saying, you know, the person that receives the services is primarily responsible for the obligation, is the language in the statute. And so again, insurance, well, helpful or not, when depending on whether they're doing what they're supposed to or not, is not a defense to a medical action. Okay, we dealt with kids. We talked about the family expense statute. We talked about the collection fee statute. Anything else I haven't covered that I know nothing about, but I'd be happy to talk about it. Okay, hey, thank you again very much. And thanks for bringing that up because those are important aspects of this.